everyone, welcome to week 8 Focus on Theory. And yeah, it is week 8 already. This is an interesting topic to figure out where to actually put in the course, because it's something that's very important that underlies everything you do as a legal researcher, but it's something that you need the foundations of your project and your plan before you can actually find a way to embrace it properly and to thread the theory throughout it. So we stuck it in the middle here, and hopefully that's the best place to discuss it. So law, like all disciplines, is a balance between theory and practice. And without practice, it's a sort of a redundant discipline if it doesn't do anything. And without theory, you never actually develop or evolve or change. So theory is very important. And unfortunately, law as a discipline has always had a fairly weird relationship with theory, and has tended to push theory to the side. And traditional legal education often had this assertion that it was somehow a completely practical vocation, and theory was something you could deal with in one subject, and that's the jurisprudence subject, and you lock theory away in one subject in the degree. It's like eating your vegetables. You don't want to do it, you just have to do it in that subject and get it all over and done with. And this has led to generations of lawyers having this strange antipathy to theory, with this idea that when I'm out in practice, I'm never going to use theory. But shows a fundamental misunderstanding of what theory is. Theory is a tool. Theory is a tool that helps you do your practice. And it helps you be critical of your practice and understand whether you're doing, are you doing well in your practice? Are you being efficient? Are you doing the best you can? And it helps you improve your practice. So an analogy I often like to use is the area of car mechanics. There's a difference between someone who's a car mechanic who fixes cars and someone who's an automotive engineer who designs cars. And they have important and connected roles, and those skill sets overlap. If you need a mechanic, your car is broken down, what you need is someone who'll fix your car. And what you don't necessarily need is someone to say, hey, there's a very interesting thing here about the history of development of automotive mechanics and the metallurgy that goes into the creation of the parts and the chemistry that underlies the engines and all those sorts of things. You don't necessarily need that. You just want someone who's going to be able to fix your car. And by the same token, if that was all anyone ever did was fix cars would never get any better. They'd never get any safer, never get any more fuel efficient, never get any cheaper. So what you need is automotive engineers who understand the theory. They understand what goes into the creation of a car, and they know how to improve it. And you need the people who can actually improve the practice for the mechanics. Now those in the example I use are two separate jobs, but in the area of law we have to be a bit of both. We have to be when there is a crisis, and our role involves us intervening and helping solve problems. We need to be those mechanics. We need to be on the ground, and we need to be able to apply those skills to solve those problems. However, if we never ever look critically at what we do, and we never join the dots and compare and contrast and do all the things that legal theorists do, then we'll be stuck solving problems, like we did in the Middle Ages, throwing women in ponds to see if they're witches or not, and crushing people with rocks to see if they're innocent or guilty and to see if they'll confess. The advances we've made in our legal and justice system come from that critical reflection. So hopefully this discussion is not going to be something that's alien to you. Hopefully you're not of the generation of lawyers who saw theory as this sort of imposition, as something that was boring or somehow removed from what they do. And you are hopefully embracing theory as something that will actually help you perform your task more easily. And certainly within the field of legal research, theory gives you a way of saying, so what? Of moving beyond the show and tell and saying, well, here's an area, and there's this, and there's this, and there's this, and there's this. Theory gives you the tools to be able to go, well, why is one thing one way or another? How do we evaluate it? And you use theory as a tool to say, does this work? We expose it to a particular theory and say, How does it make sense under this theory? Is there a better way of doing it? And a lot of the theories of law are things we use every day without thinking necessarily they're theories. So something like the concept of rights. The theory of rights is and this is probably the one I'll pick to look at the workshop for this week. The theory of rights is a very important theoretical perspective because it talks about the fact that there are legal mechanisms that people have and things that are protected by the concept of rights. If you don't have a concept of rights, you end up with legalism. We just end up with imposing rules no matter what they do to people at the end of the day. The idea of rule of law, the idea of due process, all these things that we use every day are all legal theories. So we do use legal theory all the time, but sometimes we don't necessarily recognise it as for what it is. Anyway, the videos this week will the key concept videos talk about some of these other issues and help look into that in a little bit more detail as well. So when you're building the backbone of your argument, what you need to be able to do is just thread theory throughout that, to be able to use theory to give you a purpose to what you're doing. So you're looking at something involving, well, now what we're doing with our research this term in terms of children's rights. Well, we need a theory of rights to explain why children have rights. Otherwise, you're left with an argument, well, why should we protect children in out-of-home care? There's no absolute empirical reason why we should do that unless we recognise a concept of rights and that those rights are important and that individuals are important in their own right, and these fundamental human rights deserve to be protected. So that's probably going to be the easiest one for most people to actually use as a theory in their analysis, is rights theory, but there are plenty of other things as well, and certainly critical theory that looks at power and power in society and abuse of power. That's certainly a good one to run with, because this is an area that is all about abuse of power and about the ironies of using power to protect from abuse of power. Because you've got one system that both is there to protect children, but it also is that system that is manipulated and used by abusers, particularly in those institutional contexts. So an understanding of power and how power operates would be another theoretical perspective that you could bring to bear. Now, you don't want to bring too many theories into it. That's certainly true. One of the exercises we do this week actually encourages you to look at your topic from different theoretical perspectives to see how it looks from those different perspectives, and that's a good exercise to actually understand how the theory you've chosen operates, is to actually just take a different point of view and see how it looks from that. But you certainly wouldn't take multiple theories and use all of them in an analysis, particularly for 2,000 words. You also need to do this in a fairly naturalistic way too. Sometimes you'll read articles where they'll say, I'm looking at this particular case and I'm using French Lacanian psychoanalytic theory to explain that. And you go, well, why? Why are you doing that? And often it's just the whim of the author, and the author loves Lacanian theory and decides to use it everywhere. And I would be reluctant to do that, because I think if your theory needs to be, like any tool, adapted to the task, it needs to be something that's tied to the subject matter and something that actually says something at the end of the day of importance and of application, rather than just idle theoretical speculation. All right, so and what this all boils down to is the concept of critical analysis, and we've talked about critical analysis quite a bit this term in different contexts. But at the end of the day, critical analysis is, take a theory, look at a problem, use a theory to give you a perspective on how to answer that problem, how to analyse it, how to solve it, use your other tools to solve the problem, and at the end of the day, that's where critical analysis comes from. All right, on to the readings this week. The readings discuss the difficult place of theory in legal education, which I have sort of mentioned in an overview at the start. And there's a call in the articles to be for law to be more coherent in the way it approaches theory. And they use the example of sociology, where the notions of race, gender and class form a framework where sociologists are able to say, no matter what your politics are or what your theoretical differences are, that fundamentally the theory of sociology is about race, gender, and class. And what they say is when you look at legal theory and you look at a subject like jurisprudence, you get a historical development of there's this theory, and then we believe in this theory, and then we believe in this theory, and then we believe in this theory. But there isn't a very coherent structure to this, except that there's just sort of one evolves out of the other. Dagan and Kreitner talk about the need to be more coherent and the need to actually look at something that to base legal theory on. And they suggest three different things we could talk about. One is the idea of law and policy. We know judges make policy decisions. We know when they apply the law, they apply it with policy considerations. Well, we know the people who create legislation do it under policy. Well, maybe we need to be looking at that idea of policy as what binds the whole analysis and study of law together. They also talk about another alternative is the socio-historical analysis of law. Another foundation is to actually look at it as legal history and to use a historical framework to analyse it. And the third they talk about is law as craft, which is a sort of a fancy way of talking about law as a practical discipline, and to understand how a theory of craft evolves out of even the most practical of applied disciplines. All right, the other reading from Burns and Hutchison overlaps with next week because it talks about empiricism, which we're going to talk about a lot next week. But it is relevant here because they talk about, again, some of the problems in conventional legal education. And these are things we in our degree have tried to remedy, but being limited to the structures of the priestly 11, there's only so far we can go to fix some of these things. But Burns and Hutchison point to the problem of the lack of empirical data skills in law graduates, which hits you like a brick when you go out into practice, into some kind of interdisciplinary practice, where suddenly you have to analyse statistics. You don't have to be able to determine H values and all those sorts of things and do complex regression analysis. But you need to be able to look at a set of statistics and to be able to analyse them and understand them and to interpret them. And more importantly, not to be bamboozled by people who say they can understand those statistics. So there's an important literacy component in understanding statistics. And I don't know that making everyone do intro to stats as a subject would necessarily fix that, because a lot of people don't like studying stats. But I think having a basic competency in stats is extremely important. And there's a series of videos in this week's readings I refer to, that I refer to one of the videos, but the whole series is good. That of the University of Washington, called Calling Bullshit in the Age of Big Data. And that's a really good fundamental introduction to statistical data literacy. And they point at the fact that in this day and age, there's data and information everywhere, and it's more often than not misused. And that importance of actually getting enough skills so that you can actually be alert to when someone is misusing statistics, misusing data, and using it to back up a proposition that's faulty. Okay, so that's more of the discussion for next week. But Burns and Hutchison link this to the lack of a theoretical embrace of empiricism in law, and the fact that law has been a closed system for so long and hasn't actually, until sort of the 1980s, which is a long time ago now, but until the 1980s, law was only for people who practiced law. People who graduated from law school almost always went into the legal professions, and that's totally changed now. And there was there was no pressure to actually change what they did. That doesn't mean that the lawyers didn't need to understand these things back then, but there was no external pressure. They never worked with other disciplines really to actually find out that they were deficient. And this article suggests that we need to change the way we train people, because legal careers change and they're changing abruptly, and we need to give people a broad basis of skills, because we can no longer rely on the fact that all our graduates, we only have a tiny number of graduates and they're all just going to go straight into the profession. Things have changed dramatically since those days. and we need to, make people more agile in their understanding. So that's more for next week, that idea of having those empirical skills, the data skills, as well as your other skills. But it ties back very strongly into this week in that there has to be a theory of law, a theory of legal research, and an understanding of what we do that embraces those things. And that's what we're trying to do in this subject, is to be able to say you need to know your legal authorities, but you also have to balance that with a competency, a literacy in the discourse from other disciplines that help you understand that. There's no point in understanding how to sentence someone to deter them from committing crime when the statistical data shows that deterrence doesn't work. You end up just, trying to deter people for no good reason without actually understanding that what you're doing has no good reason. So you need to be able to understand those things. All right, what else do we do in the study guide this week? The section on navigating the law focuses on databases and databases that contain journal articles and so on. And this is the point where I encourage you to learn how to use these and not to rely on Google, of course, because most of the research that you'll need to use is locked behind paywalls. And even if you might be able to find a reference to an article in Google, chances are it will be the actual article itself will be locked behind a paywall that will ask you for money. Some of those databases will be ones that the university has a subscription to, and then you'll need to be getting through the university library site and be able to access them that way. Unless you want to pay $35 an article a pop, which they ask for or whatever, which of course you don't want to do. You want to actually use those databases that you have access to while you're a student to get that information. This points to larger problems in the field of research, and one of those is the way in which a small number of corporations have basically controlled and taken over the research publication system and profit massive profits from that system. And particularly in areas of health, people have started to challenge this and say, how come journal articles that are from publicly funded research are being published in these journals where private corporations are charging people access to that publicly funded research? And if that publicly funded research is something like cancer research, then surely that's something that's so important we shouldn't be allowing a small number of people to profiteer from it. And it's really important these days because, back in the old paper days, publishers did more. They actually had to print things on paper. They had to distribute them. They had to get them out to libraries. They had to sell subscriptions to libraries. But of course, in these days, most of what publishers do is just produce something as a PDF and then lock it in behind their paywall service. And all the work is being done by academics. All the writing, the reviewing, the editing is all done by academics who are paid to do it, but they're paid out of public money. They're not paid by the publishers to do it. They're just paid in their normal jobs to do it. So in many ways, it's a bizarre situation we find ourselves in, where someone has managed to own so much of knowledge that they had nothing to do with creating. And the university systems are complicit in this, because the criteria for advancement and for promotion has always been publication. And these corporations have then used that as a way of saying, well, we're going to force academics to publish in our journals that we can charge for. Now, there is a good side to this. Things are starting to change. There are increasing numbers of open journals that produce their research for free, and that's very, very important. People are also using private archiving of their articles as a way of accessing them as well, and this is going to be a very interesting legal issue, because people have been using ResearchGate and they've been using all those different research services to say, well, my article is published and here's the pay version, but I'll also put a copy of it on my private research network base. And of course the publishers are not very happy about that, because they make millions of dollars I think it was last year, the CEO of Elsevier gave himself a $45 million Christmas present because they had made so much money that year. So they're not very keen on the idea of the individual authors giving this stuff away for free. So there's an emerging battle. You think the world of research and academia is kind of boring, and maybe it is, but there is a massive cultural battle that is starting to emerge about what happens to all this public research and who owns it and where it goes. So stay tuned. I think it's going to be interesting. And if you study intellectual property law, this is a core issue for things like copyright and the way in which the copyright law enables, people like companies like Elsevier to make massive profits and to keep research out of the hands of people who need it. And they keep putting the prices of those subscriptions up every year. So in terms of getting back to your needs as a researcher, Google Scholar is a reasonably good place to find articles, but you'll find quite often that the links they go to are to paywall subscriptions. But if you're a little bit diligent, you can often find those articles in those private repositories in things like ResearchGate. And sometimes ResearchGate allows you to request a full text copy from an author. So they will have full text copies that they'll only release to people who ask for them, rather than having them available. So it takes a little bit more time, but there are ways of finding these things if we don't have the journals in our particular university database. And unfortunately, the university is cutting the number of subscriptions every year because the prices are rising. And your student fees aren't going up at the same rate that the costs of the journal subscriptions are going up. So every year they have to be very ruthless and look at it and go, well, no one's looked at the Journal of Public Law in the last 5 years, we're going to delete the subscription to it. And that happens just before you get an assignment that has an article in that journal that's absolutely essential for you to complete it. But that's the economics of this, and that's the economics of the naked greed of the publishers in this field. And the importance of the emergence of open publishing. So, as I said, if intellectual property is your thing, really interesting issue that's emerging. All right, last thing to talk about is the workshop for this week. And we'll be looking at creating a literature review, or at least a mini literature review. A literature review is basically just a formal way of keeping notes of your research as you go, because you can't keep everything in your head. And a literature review is, rather than just writing weird notes on scraps of paper, is a way of actually fleshing out those in an article by article way as you move through your research sources, be they cases, journal articles, or whatever. But generally, a literature review in most disciplines is just journal articles, and you summarize each of the pieces as you go, so that when you come back to write up your paper, you've got your summary, you've got your quotes that you're going to use, and you know where they come from, and you've got your proper references, and everything is properly laid out. So we'll look at that as a process, and there are different styles used in different disciplines. And some disciplines actually take this very, very seriously. And in psychology, people publish literature reviews. You can read articles that are just summaries of other articles, which seems slightly crazy to me, but I'm not a psychologist, so who am I to judge? But I guess it's a great research source if you're looking into, delinquency in a certain field. If you can actually find literature reviews other people have done of other articles, then that gives you a head start in finding that information. Now, there's no tradition of that in law, and the idea of a literature review has only recently really made much of an impact in law, because of the way legal research has sort of changed over time. But we'll look at some of the tips for doing that in the workshop coming up. And it's really, I guess, also a way of just thinking about being more formal and more careful in the way in which you keep notes as you go. And that becomes very important when you move on to bigger projects. 2,000 words, you can probably keep most of your sources reasonably in your head with some note keeping. But if you're going to move on to honours, and you're going to do a dissertation, if you're going to move on to a PhD, you've got enormous amounts of material you need to be able to access, so you need a really good way of organising those notes. All right, so that's all I had to say leading up to next week, and I will see you in the workshop.